Hi, y'all, and welcome to tonight's live stream. As you know, we followed the Delphi case from the very first day to the very last. I went in person and was there for an entire month. Without question, the most important evidence in the case, in my view, was the confessions of Richard Allen. And what made those confessions particularly compelling to the jury, I think, is likely to be the fact that there was one fact in there that the prosecution said from opening statement Richard Allen could not conceivably have gotten unless Richard Allen was actually the one who murdered Libby German and Abigail Williams. The prosecution argued that he confessed to multiple prison guards and to Dr. Monica Walla, his psychiatrist. Dr. Monica Walla described a very detailed confession. Almost all of them were just, I did it, and something very vague. There were also confessions to his wife and to his mother, which were also similarly just generic, very general, I did it. But the confession to Monica Walla was different. It was far more detailed, and it had one fact the prosecution said was critically important. And that fact was the white van. We were told that he said he was about to R the girls. It was going to be an SVSA, and that's all he was going to do. And then he saw a van go by and he became frightened. And when he saw the van so near him or just going by, he became frightened, and he decided he had better, he abandoned his idea of SA and instead decided that he was going to murder Libby and murder Abby, and that's what happened. So that was the prosecution argument, that he saw this van. The van became a huge part of the case. It became one of the important facts that was heavily fought. And it was not a fact that had been even important before trial, but it became all important during the trial. At trial, a man named Brad Weber, who lived on the property running adjacent to where the girls were murdered, and there was a path that went through there, and the prosecution brought him to trial. He said he had been at work that day. He came home right about that time, and lo and behold, drove a white van directly beside the creek, right near or across from where Richard Allen was with the two girls. And that's the van that frightened him. It was a large white van. The question then of whether or not Brad Weber actually drove that white van through there at that time became important. The defense wanted to show the jury that although Brad Weber claimed he drove straight home from work at trial, that wasn't what he had told the FBI when he was interviewed shortly after the event. At that time, what he told the FBI was that instead of coming straight home, he had gone out to check his ATM machines. He owned and serviced ATM machines. He'd gone out to do that, and only afterwards did he come back. So, but at trial, he was very clear that no, he came straight home. That became confirmation, an actual fact that could confirm this confession, because the defense said this confession was fake. This confession was not based on the idea that Richard Allen was actually guilty. It was based on the way he had been treated in prison. He'd been treated so abysmally that he just fell apart psychologically, and he confessed. So the defense has now filed a motion to correct errors. This is kind of a strange motion to be used for this, to introduce new evidence. That isn't the way it normally works. A motion to correct errors would normally be something more administrative about what happened in the trial, but the defense has used it to drop some bombshell new evidence. And what we're going to talk about tonight is the new evidence about the white van. There were 4 different kinds of evidence that were talked about in this motion to correct errors. Let me pull that up for you. Oh, wait, I don't want to spoil the surprise on that. We'll pull that out. Okay, so here it is. So this is the motion to correct errors, and I'm going to try to, I'm having trouble finding it. There we go. Okay. That's probably, I'm not going to be able to read it myself if I do it that big. Let's see. Okay, there we go. That's pretty good. All right. So there are 4 different things that they argue. First, they argue about the safekeeping. The safekeeping is the order that took him from jail, which is where people would normally be placed when they're arrested, and put him in prison, which is not where you would normally be placed until you were actually convicted of the crime. But he was moved immediately from jail straight over to prison. And that happened without the presence of counsel. One of the things that the defense wants to prove is that he could have had counsel because he had hired somebody and they just didn't notify him. So that they spend a lot of time on that argument. And we will deal with that another day. But there are other arguments that are made. Let me head over to where I have my notes. So there are 3 other arguments that are made. The one we're going to talk about tonight, the van, that there are new facts about the van that prove what Brad Weber said was false. That was, to me, the one I wanted to cover right now because it is new. Thirdly, Ron Logan's confession to his cellmate. There was some indication of that before, but we got a lot more detail about that in this brief. We'll cover that another night. And then issue 4 was, if you remember that issue about the headphone jacks that were plugged and unplugged at times when, according to the prosecution, Libby and Abby were already dead. So who was doing this? And there was a Google search by one of the law enforcement officers testifying during a break, and he came back and said, well, it could have been water and dirt. Google says so. And the defense was definitely objected to that, but they now believe they have new information from an expert about that. So we'll deal with that another time too. Tonight, I want to talk about what is absolutely shocking about the white van. And this is particularly important, I think, because of the fact that it was sort of a surprise at trial. I don't think that the defense fully expected this. I don't think anyone did. And so we're going to cover that tonight. If you are looking for the Natalie Cochran trial that I've been covering every night from the beginning of the trial, we're now on day 4, then I just covered that and finished it. You can watch it right after this live stream. You don't want to miss this. But if you're not watching the Natalie Cochran trial coverage, you really should start watching that. I'm doing it every night, and you only have 4 to go back and watch, 5 if you count the overview I did. And you can be all caught up. It is a crazy case where this woman, a pharmacist, has been accused of murdering her husband by injecting him with insulin. She's also been accused over time of running a Ponzi scheme that took all of her mother and father-in-law's money and ripped off her own brother and parents. She's also been accused of stealing $10,000 from the Little League and faking cancer. The case is absolutely wild, and you really should be following it. So please, follow that. Afterwards, I'll link it at the end when we get finished and YouTube has processes. Also, a special surprise, tonight at 9:30, I will be on Court TV talking about this case and this motion that we're about to talk about right now. So special shout out to the first 5 in the chat: Olivia's mom, aka Sue, Jebby Camphor, Katie W., Monica C., and Sunrise, South Dakota. So welcome to all of you, and welcome to everybody into the chat tonight. Thank you for being here. So let's get started on what the new information about the van is. In violation, and we're going to read this section about the van. In violation of the Due Process Clause of the 14th Amendment, and he cites a case, Napu v. Illinois, and its progeny, the state presented the testimony of Brad Weber, that Mr. Weber arrived home in his white van about 2:30 p.m. on February 13th, 2017, either knowing that testimony was false before it was elicited or failing to correct it once it had been elicited. So they're arguing that the state presented evidence knowing that it was false, or at a minimum, once they realized it was false, they should have corrected it. Now, already, my initial thought was that they were going to be talking about the time it took to drive from his work, where he clocked out, I think it was at 2:02 or something like that, and the time that he arrived home, because it was already very unusually fast for him to get home. But that is not what they're talking about. They're talking about something different and more important. And they start by just talking about the law in the case about the state not being allowed to solicit false evidence and about not being allowed to let it go uncorrected if it figures out something's wrong. At trial, the undisputed evidence was that Libby's cellular telephone stopped moving at 2:18 p.m. on February 13th, 2017 for 7 minutes until 2:25 p.m. It then started moving again and stopped moving permanently at 2:32 p.m. In closing argument, Mr. McClellan called it, that's the prosecutor, called it a hard fact that Libby's phone stopped moving at 2:32 p.m. And remember, the phone was found underneath Abby's body in that area in the woods where both bodies were found. The phone was underneath a shoe, which was underneath Abby's body. The state introduced an alleged confession by Dr. Allen to Dr. Monica Walla. And I just went through what that was, so we'll skip on down to here. The state also introduced the testimony of Brad Weber that he left work at the Subaru factory in Lafayette, Indiana at 2:02 p.m. I'm going to skip a little bit, and arrived home in his white cargo van at about 2:30 p.m. From Mr. Weber's testimony, the state argued Mr. Weber's arrival home in his van was what interrupted Mr. Allen, causing him to take Libby and Abby across Deer Creek to kill them on Ron Logan's property. The arrival of Mr. Weber's van at about 2:30 was a detail only the killer would know, said the state. That is true, and it was extremely important in the trial. This was a critical fact that became part of the state's entire argument about why Richard Allen was guilty. But the problem is the state also contended that Libby and Abby died near in time to 2:32 p.m. when Apple Health data from Libby's phone showed that the phone stopped moving. If the arrival of Mr. Weber in his van interrupted Mr. Allen, forcing him across Deer Creek, Mr. Weber would have had to arrive near his parents' house at the end of the private drive before 2:32 p.m., when, according to the state, the phone stopped moving and was located on the north side of Deer Creek. And remember, like I said, according to the state, it landed on the ground in that clearing in the woods, and that then the body was found on top of it. So the last time it moved was 2:32 p.m. That's what they said. In fact, Mr. Weber could not have arrived anywhere on the private drive before 2:54 p.m. on February 13th, 2017. His arrival at about 2:30 could not have been a detail only the killer would know, because it did not happen. The state knew or should have known as much, and the state either elicited Mr. Weber's testimony about the time he arrived home, knowing it was false ahead of time, or failed to correct that testimony once it had been elicited. So once again, saying the state either knew this, or once they figured it out, they should have done something about it. And here we go into the new evidence. Defendant's Exhibit 3A, as attested to by Matthew Hoffman, and I don't know who that is, in Defendant's Exhibit 3 is a video recording made on February 13th, 2017, the day Libby and Abby disappeared, by a security camera that was in the house at 5998 West County Road, 252 North. The video recording was provided to the defense by the state and has therefore been in the state's possession. Now, the state is also going to argue, well, if we had it, so did you. So you could have argued this during the trial, and you didn't. So I can guarantee you that will be a huge part of the state's argument. And they talk about the state, the way the video faced, how it recorded based on the date and timestamps on it and so forth, and that it was set 12 hours behind. So 12 a.m. was really 12 p.m., etc. That the security camera had a wide angle lens that captured video of traffic right on that road. And that was the only road by which a vehicle could enter the Weber property. So they're saying, this is it. This is, if there's a van, then it had to have, that came along this road, then it had to have gone on this, down this particular course. According to the time and date stamps on the security camera recording, Exhibit 3A shows a white vehicle going north on N625 West entering the frame at approximately 2:44:33 p.m. on February 13th, 2017. Exhibit 3A also shows a white vehicle continuing into the private drive to the Weber property at approximately 2:44:54 p.m. Exhibit 3A is viewable on YouTube. And they talk about the fact that Exhibit 3B is a video file that contains 3 zoomed clips. And I'm going to show you those. Here they are. Those are the zoomed clips. And you see in the corner, let me make this as big as possible because I think it's super hard to see. I think you can see my cursor, but it's not in the exact spot. I think right now you can see it. This is where the van is. There's a little red circle right there. And since I'm not sure which cursor you can see, or maybe I have double vision, I don't know. So it's right where it's in the lower left-hand corner of these photographs. And they say, we see a white van going along. It's clearly daytime. And we see a white van going along, and then they blow it up and they say, we believe this is Brad Weber's van. There's a picture of Brad Weber's van that they also include in their motion. So let's head back over to the motion and talk a little bit more about what they say. So 3B is a video file where they zoom in, and then 3C is the still photographs that I just showed you that zoom in as well, and they show at each magnification level. So they're trying to show, here is the van. We believe it's a white van, and it's the only van that goes through here. And they'll talk a little bit more about it. And they circle it here. You can see the close-up of it, and they have it circled right there. Exhibit 3D is a photograph of Brad Weber's white cargo van provided to the defense by the state and therefore has been in the state's possession. The photograph of Mr. Weber's white cargo van in Exhibit 3D appears to be at least similar to the white cargo van as it appears in Exhibits 3B and 3C that we just talked about. Other video, excuse me, tell you what, let me get a sip of water. Other video files produced by the security camera in the state's possession, provided to the defense in discovery and covering the time from 2 p.m. to 4 p.m., do not show any other van driving north on N625 West into the private drive to the Weber property or traveling east on West 252 North during that time. So, and they draw their conclusion here. If Mr. Weber returned home in his cargo white van, he could only have arrived home some minutes after 2:44:54 p.m. on February 13th, 2017. And that's 12 minutes after the last movement of Libby's phone. So her phone is on the ground in the clearing, 2:32. She's already across the creek. And according to the prosecution, it's right about then that the girls are killed. And that indication is when the phone stopped moving. It was really in about that time. But he's saying, well, if the phone, they're saying the phone is on the ground at 2:32 p.m., but he could not have been driving by in a white van then. He could not have driven by until after 2:44:54 p.m. Now, to some degree, they are sort of giving up their argument about what he said to the FBI. To the FBI, he said, yeah, I went and checked all my ATM machines. I wasn't home until, I think, after 5, something very late. But they're seeing a white van, and they're saying, okay, maybe this white van was Brad Weber's van. But what we know is it wasn't there at 2:32 p.m. It wasn't there until 2:44. Now, it is possible that, and I think the state will probably argue, the time that the phone stopped moving, maybe they dropped the phone, and he's considering this SA that he's talking about, and he decided, and at 2:44 or shortly after, when the van drives by, is when he decides to murder the girls, and instead does that instead of what he had been planning. But The timing does not match exactly what the state had said. The state had said that the girls were killed very close in time to when that phone landed on the ground to when it stopped moving at 2:32 p.m. And they felt it was a much tighter time frame. So the defense is saying, no, it wasn't. We can prove he could not have been driving by before 2:32 p.m. We can prove that. Either the white cargo van shown in the exhibits is Mr. Weber's, with him arriving home some minutes after 2:44:54 on February 13th, 2017, or it is not. In either event, no white cargo van or any other van entered the private drive to the Weber property after 2 p.m. and at or before 2:32 p.m. on February 13th, 2017, the time the extraction of Libby's cellular telephone shows the telephone stopped moving. Let me say thank you to a few people. Michael, thank you. I am appearing on Court TV at 9:30 tonight, and I am unbelievably nervous. So please come and be very supportive and kind. I would be very grateful. So that'll be over on Court TV, and I'll be talking about this case right here, the one we're talking about. B. Jean gifted 5 Lawyer League memberships. Thank you so much for doing that. I really appreciate it. And Kelly Jane says she's been a member for 2 months and that she started watching during this trial, during the Richard Allen trial. And now she watches the live streams, even though they start at midnight. I'm very grateful to all of my European followers. And there are a lot of y'all. And one of our moderators, Marlon, is from the Netherlands. So he also does the late shift. And I'm very appreciative to all our moderators, Marlon, Mama Pinks, and Denisepelton. Thank you all so much. All right, so let me keep going with this, and then I'll thank a couple more people in just a minute. Defendant's Exhibit 3E is a redacted FBI subject information sheet for Bradley Weber and is dated March 3rd, 2017. So a little bit more than 2 weeks after the girls first disappeared and their bodies were found the next day. The unredacted version of Exhibit 3E was provided to the defense by the state and has therefore been in the state's possession. So they're going to say, here's another reason that we believe the state had information. They knew Brad Weber did not drive his van through during that time. And it was ultra important because it was the support for that very specific fact. They said, Richard Allen said in his confession, this was the support, and it didn't really pan out. That's what the defense is arguing here. Exhibit 3E, the FBI subject information sheet for Mr. Weber, says, on 2/13/2017, Weber's phone pings to parent's address overlooking crime scene, initially at 2:50 p.m., and repeatedly pings around the property until 11:55 p.m. That Mr. Weber's phone first pings to his parents' address at 2:50 p.m. on February 13th is consistent with the video evidence in the exhibits showing that he could not have arrived home in his white cargo van until sometime after 2:44:54 p.m. that day. And it does fit pretty tightly. If he's driving by on the road out there at 2:44 and 6 minutes later, 5 minutes later, really, his phone first begins pinging on the address, then it does fit. It does seem possible that at about 2:50, he arrives there. That's substantially after Libby's phone stopped moving. Her phone stopped moving at 2:32, and then at 2:50, Brad Weber is the first time the defense says that Brad Weber could have arrived there. He did not arrive before. That's their argument. From both Exhibit 3A, the security camera video recording, and Exhibit 3E, the FBI subject information sheet for Mr. Weber, the state either knew that Mr. Weber's testimony about the time of his arrival home would be false before it was elicited, or failed to correct it once it had been elicited. And I will say, I think the state brought him because he was going to talk about the fact that he drove straight home from work and had this white van, and it fit with the confession that Dr. Walla wrote down. So that was the purpose of him being there, I think. When the state introduces testimony it knows will be false or fails to correct testimony it knows or should know to be false, once elicited, a conviction must be vacated or reversed if that false evidence may have had an effect on the outcome of the trial. What the state is going to argue, though, is, look, you had every right to, you may disagree with this testimony, but you knew everything we knew, and you didn't correct it at the time. That's what I expect the prosecution to argue in response to this. And they cite from a case, United States v. Cardina from the Seventh Circuit, saying to receive a new trial, the defendant must show, one, that there was false testimony. And we'll talk about that in a minute, because was it really, he simply said he came straight home from work. He may have said it was at 2:32. I don't recall. The timing was ultra important. Even a matter of 10 or 15 minutes actually does make a significant difference here. But I don't know if he actually testified falsely. I don't know if he said I was there at 2:32 or if he just said I came straight home. I think he gave a time. I have to go back and check that. If any of you know, put that in the chat, please. Number two, that the government knew or should have known it was false. And certainly the impression created, which was that it was at 2:30-ish, was false. And that there is a likelihood that the false testimony affected the judgment of the jury. And I think it is very likely that it did. It was extremely important to the state. It was something they argued in opening, something they argued in closing about this confession, and about a fact within the confession that only the killer would know. To obtain Mr. Allen's convictions, the state explicitly relied on Mr. Weber's testimony about the time he arrived home and used that testimony to corroborate Dr. Wallace's rendition of Mr. Allen's statement that he became scared after he saw a van, so he took the girls to the north side of Deer Creek and killed them. This was the only statement allegedly made by Mr. Allen that contained any detail of the murders that might be true. Now, one thing in that I don't recall, if we had a transcript, but I don't recall him saying that he saw the van and then took the girls to the north side of Deer Creek. I do recall him saying that he saw the van, it scared him, and he changed his plan. His initial plan was to R them, changed that, and decided instead, I'm going to murder them. It's the crossing to the north side of Deer Creek that I'm not as sure about. And that's actually an important fact, because it would mean even longer before the phone could end up on the ground on the other side. If they're already on the other side, they're seeing the van and then he gets scared, maybe it's possible. But if they're still on the same side of the creek as the van, and only then do they cross the creek, only then does the phone end up, then it's truly impossible, because the phone stops moving on the other side of the creek at 2:32. This was the only statement allegedly made by, I already read that. The state, therefore, cannot show Mr. Weber's uncorrected false testimony about the time he arrived home did not have an effect on the outcome of the trial. I think it definitely had an effect on the outcome of the trial. If this is incorrect, it was definitely argued, and argued hard, by the state. Alternatively, were the court to find that the state did not know or should not necessarily have known about Exhibit 3A, the security camera video, and Exhibit 3E, the FBI subject information sheet for Mr. Weber, then both exhibits constitute newly discovered evidence that would probably produce a different result at a new trial. Accordingly, for either reason, the court should either vacate Mr. Allen's convictions or set this motion for a hearing. This is hugely important. We heard nothing at all, and let me go ahead and pull out. We heard nothing at all about this during the course of the trial. We did not know about this video camera that suggested that Weber couldn't have driven by then. And what I'm guessing is because he came and said something contradicting what he had told the FBI. This was not an argument that the defense was necessarily expecting. They were probably expecting him to stick with that story, that he hadn't been there. You can see where that might be in his best interest, because at the time he was being interrogated, he wouldn't want to be there when the girls were murdered. He would want to have arrived much later. And so you can see where he might have an incentive to say that he arrived later on instead of was there at the time. But when he came to trial, he said something different. He said, I was there shortly. I came straight home after work. I did not check the ATMs. And the defense actually had a lot of trouble getting someone to testify that in fact, he had agreed that he had been checking his ATMs. They tried twice to get him witnesses. The first witness said, yeah, I don't remember that, even though it was written down. And the second witness said wasn't allowed to come because they were going to have to testify by video camera. It was in fact, I think it was the day of the election, the day before the election. They wanted to take his testimony by video over the weekend beforehand so they could play it and he wouldn't have to be absent, because he could not be. He was in charge, they said, of security for the election, right, and in all of Texas. And so it was a significant job he had, and he couldn't just leave to come to come and testify. So they wanted to do it by video, which frankly was a really realistic, very normal request, but the judge denied it. And so they didn't have him testify. It ended up that other people sort of put that in evidence, so it wasn't left out that he had told the FBI, had told other people that he checked his ATM. So it ended up being part and parcel of the case. I think the jury did know about the fact that the defense says, yeah, he wasn't really home then. He was off doing something different. But now the defense says he may well have been home, but he wasn't home at 2:32. He wasn't home until 2:50. And the state's whole case rests on the idea that this confession was true because he saw the van, that he acted on the strength of seeing that van. And now we can prove the van could not have been there at 2:32 when the phone stopped moving. So let me say, tongue-tied here. All right, let me go to Nick's comment. We all speculated for years because we knew something was off with this case, so off with this case. And now finally the actual evidence is coming out, and it's worse than I could ever imagine. It certainly is a surprise, and it seems a surprise also to the defense. And I really do think it may be that people had this evidence, but because they were not expecting Brad Weber to come in and testify as he did, nobody thought this was important. Nobody thought to look back at this evidence and see, hey, was there a white van? What time was the white van? Oh, thank you, Avalon, who has been a member for 4 months. Can't wait to see me on Court TV. Thank you. I appreciate that. And Bone Mama gifted 5 lawyerly memberships. Thank you. And as did Bid Dog 5758. Thank you both. I really appreciate that. And Kathy says, thanks for the great explanations of court proceedings. I really appreciate all of you. So I am going to take a few questions. We won't go too long because I've got to finish up getting ready for the Court TV. But I did not want to hold off on giving you this. I think it's incredibly important. I think it really changes the perception of what those confessions mean. I thought those confessions were the most important piece of evidence in the case. And the prosecution argument that at least this one confession had a detail that only the killer could know was critically important to whether or not we could believe those confessions. The defense argued you can't believe them. There's no way you can trust them given how he was treated, given that he was in psychosis, given that the psychiatrist acknowledged that he was having mental problems. So that was, I think, an extremely important argument. All right. Oh dear, Marlon is telling me that Annie K's 11th month membership was missed. I'm so sorry, Annie K. Annie K has been around. That would be when we started having membership. So it's 11 months ago. So thank you so much. I really do appreciate that. And I'm sorry I missed that. Thank you, Marlon, for letting me know about that. All right, so let me back up, make sure I get questions. I think that'll be the first one about right. I've gone too far back. All right. Nope, there's Mama Pinks. Okay. Annie K has a question. Given this judge, is there any evidence or revelations you see being enough for a new trial? So this is just a motion to correct errors. This is really probably not the correct vehicle for this request, but it is an important communication to the public. It's also going to be important on appeal. It's just now on appeal, the prosecution is going to say, hey, they had this evidence. They chose not to make these arguments. Don't blame us. You don't get a new trial because you choose not to argue certain evidence because And you can see where an appellate court would agree with that, because otherwise people would just hold back certain evidence, like keep it to themselves, and then say, oh, well, we didn't argue that on that trial, so we get a new trial. And so the courts say, yeah, you got to use everything up front. If you know about it, you need to use it. That will probably be a prosecution argument here. So it is given. So let's go back to Annie's question. Given this judge, is there any evidence or revelations you see being enough for a new trial? The answer is a big no. There is no way she's going to give them a new trial. That's my opinion. She's going to say this is not a correct vehicle for saying these things. You could have said them before, and no. Or maybe she'll just say no. I don't know which. But I do not think there's any possibility that she's going to give them any kind of relief on this. All of this is just a message to the public and a message to the appellate court. I think at this stage, that's what this is about. In this particular case, what they're arguing is the prosecution knew this, and the prosecution is not allowed to hold back. If it knows the truth, it can't pretend it doesn't know the truth and allow people to make arguments against it. But the prosecution will say, hey, you knew it too. Reasonable inferences. You could have made the argument yourself. Judy asking a question about how could Richard Allen move the bodies by himself? Well, interesting that you asked that, because there is some information in what we're going to cover next. So do not forget to subscribe and turn the notifications on. We haven't even covered Ron Logan's confession to Ricky Davis. And that is what the defense argues is newly discovered evidence, and that the confession was held back. It wasn't shown. It's definitely true that it wasn't shown to the jury, and that Ron Logan, who owned the property where the girls were found, confessed with some details that, in their view, only the killer would know. So we will cover that in the next video. We're not going to cover it tonight, but I just wanted you to know about that. Okay, so and as now, Ron Logan also talked about how he moved the bodies, and one of the things you might remember that we covered, there was a long trial, so I don't know if you'd remember this detail, but there was suggestion that maybe Libby's arms were up because somebody tried to pull her, and somebody was trying to move her. All right, so some nobody, and that will figure in too. Some nobody. How long does it typically take for the court to answer this motion? This isn't a normal motion. This is not a motion that would normally be made in this way. But as far as how long it would take, I don't believe she'll take very long at all. The defense counsel even had to make a special appearance because they've actually been removed from the case. She removed them promptly. And they said, well, you removed us too soon. We had some things we needed to file. I think she may say, you aren't even counsel. I refuse to accept this. I think it's more likely she'll allow the prosecution to brief it, and she'll go ahead and deny it fairly promptly. That would be my guess. I don't think there's a specific date or deadline for her, but I think that's how it'll work in practical terms. N4A, is there proof the time is correct? In trials, the owner of the camera is asked, and sometimes the time is wrong. So they made the argument that the time was actually 12 hours off, but that it was exactly 12 hours off, I gather. So AM, PM. So they feel like they have the correct time. I don't know how they know that. I assume law enforcement checked it at the time it was collected. Maureen Goodman wants to know, what are the chances it's overturned? Well, if you look at chances, then it's not likely, because the majority of cases aren't overturned. So you just look at that and it's unlikely. It's far less than half. In this particular case, I would say the arguments are stronger. Are these arguments that are going to tip it? Maybe not, but are they arguments that can make a difference in a new trial? I think they definitely are. I think this one in particular that we covered tonight is. Neuropsych Xena, what do you think will result from this motion? I think it will be denied. But I do think it's an incredibly important communication to the public about facts that were not presented to the jury and that probably should have been. But whose fault is that? Is that defense or prosecution? That'll be one of the arguments that's made. Deanna asking me, didn't his psychosis start after his first confession to his wife and when the defense lawyers rushed to see him in prison? The argument we looked at, we have a whole timeline actually, Deanna. If you go back into what we covered at trial, I did a whole timeline on the confessions. When did they start? What was the evidence around psychosis and when it began to develop? And the psychosis, or at least symptoms, did begin earlier. The first confessions weren't really to his wife. They were more to guards. And so we put all that together, and you can go back and look at that. I think you'd really like that. I think you'd be very interested in that. Okay. All right. Looking for question marks only at the beginning, because otherwise I have no hope of spotting them in the chat. Is the Franks memo unsealed? Yes, it is, Loretta Powell, the Franks memo. Actually, the Franks memo was filed publicly. And so, excuse me. So, Johnny Slowpoke, are we saying it was Ron Logan the whole time? So I'm not saying that, but that is definitely an argument that is being made, at least possibly because he confessed. Now, I think a critical point to remember is the defense doesn't have to prove Ron Logan did it. The defense only has to prove that there is a reasonable doubt, and prove isn't the right word. They just have to, the jury has to be left with a reasonable doubt that it was Richard Allen. And if Ron Logan confessed in a credible way with facts known only to the killer, then Ron Logan might be the person, and then that might be a reasonable doubt so that the ultimately the conviction would not happen. That's exactly what the defense is trying to argue. Look, if we can show Ron Logan there's a reasonable argument that he did it, that's the reasonable doubt we're looking for. Wesley loves Oktoberfest. Yes, Ron Logan is no longer living. Sin Diesel asks about Ron Logan's background and past criminal history. And there were some things around DV, as I recall, but I don't remember all the details on that. And that would not come in any event, even if true, it wouldn't come in. All right, looking for question marks at the beginning. We are all vultures asked, what about the bullet found at Richard Allen's? It must have been planted. So what I think we are all vultures is referring to is a gun was found at Richard Allen's home that the prosecution says matches an unspent bullet casing found at the scene between the bodies of Libby and Abby. And they say these are a match, like they fit together. And we can prove this unspent bullet casing matches this gun. And the two of those together show Richard Allen's gun fired, that the unspent round cycled through his gun and his gun only. And that was the argument made by their expert at trial. So I think Richard Allen's team would make the same argument next time that they did this time, which is this whole idea that you can match an unspent cartridge to a particular gun is nonsense, that doesn't really fit. These two don't fit. And the whole concept of doing it is ridiculous. So I think that's what they would argue. They did lose their expert on this. So if they got another trial, they would probably come up with an expert who would pass muster and could talk about the idea that you can't match them up. They did lose one of their two experts on that. If he gets a new trial, will it be a different judge? Twisted Taurus asks. Not necessarily. Normally, it would go back to the same judge. Would something different happen this time? Maybe. Okay. One or two more questions, and that'll be it. Looking for question marks at the beginning. It's not Ricky, Grim Reaper said. I don't know how to pronounce that. Is it Richie? So if you know Grim Reaper, let me know, because I don't know how to pronounce that name. Okay, looking for last question. Did they DNA test Ron Logan? I would think yes, Johnny Slowpoke. But remember, they didn't find any DNA findings on the girls. There is a reference in what we're going to cover next. You're just going to have to hang on, but there's a reference to Ron Logan believing that his blood may have gotten on the girl's clothing. So there was, we don't know, but there doesn't seem to be any suggestion in this anyway that there was a connection, that there was any kind of DNA found that might have been a match to Ron Logan. So I don't know the answer on that one. How does this fit with the no third-party evidence by the judge? Jan S. asked, well, the Ron Logan would have been left out no matter what, because the judge ruled absolutely nothing comes in with third party. So that would have been left out. And it's so riveting. There are handwritten notes about what was said. We will cover all of that. And if I could, I'd do it tonight, but I am going to be on Court TV shortly, and I've got to go get ready for that. So I'm not going to be able to do that. Oh, thank you, KS, who's been a member for 11 months and took her membership, her membership notice just to encourage me. Thank you. I really appreciate that. Tonight, we have a very special outro. My husband passed away May 8th. His name was George. And so it was his birthday yesterday. And Marlon, one of our moderators, our other two are Mama Pinks and Denisepelton. I'm so grateful to them. Marlon made a special gift for me. He did a drawing of my George and did this little outro for me. So it's really special to me to be able to show this to you. And I want to say, it looks really stylized, but I'm telling you, that's really what he looked like. I mean, I thought he was unbelievably handsome. And here is my George. Happy birthday, George.